You're in a really rocky relationship and you realize this is not good, not for us, not for the kids. So you decide, you know what, we're going to do some nesting. Unfortunately, a month later, things blow up, you get in a big fight, you end up getting arrested, you get hauled away, your husband stays, ex-husband, keeps the kids, and starts his legal maneuvering. You end up with supervised parenting time, but you know that you're innocent. So you take your criminal trial to trial, and you end up getting a not guilty verdict. And yet, at the trial in the family law court, you lose. Your husband gets full custody, and you're going, how can a judge ignore my not guilty verdict like that? Hazelton v. Hazelton just came out, and I'm going to discuss that case with you to explain what she did wrong and what you should do to avoid the results she got. I'm Jim Kraayeveld, founding attorney at Kraayeveld Family Law. I've been doing this for 30 years. In the Hazelton case, January of 24, the parties separate and they start nesting. Nesting is where the kids stay living in the family home and the parents take turns coming in and out of the house to spend time having parenting time with the kids. In Hazelton, a month later, they get in a fight. Mom gets arrested. She gets carted off. Dad files for temporary custody so that she has supervised parenting time, but she fights it. 8 months later, she goes to trial and she gets a not guilty verdict, which of course is known to the family law trial judge when they start their trial in December that ends up in February, 12 months later. Now, here's a little issue that popped up that mom did wrong in the first place. They get ordered to go to the friend of the court. At the friend of the court, Dad introduces a ring camera incident where mom is shown being aggressive on the driveway while this is all in place. If you're going to have parenting time exchanges, don't do it on a driveway where there's a ring camera. Everybody has ring cameras and all of that gets recorded. She didn't get good advice from her attorney. Should have worked out an arrangement where they were on neutral grounds for the exchanges of the kids. Number two, don't get out of the car. If you're going to get out of the car and you're going to do something aggressive or do something that wasn't beneficial to your case, it's going to get used against you. Again, probably bad advice from the attorney or failure to advise. While at the friend of the court, because the court ordered a friend of the court investigation, which we've discussed in other videos, psychological evaluations were required. The parties agreed to do that. The parties were invited to produce whatever evidence they had in support of their case. The husband, of course, introduced this ring camera. The husband introduced the body cam footage from the police of the initial incident. Mother said she had individual counseling records, but she never produced them. So, in addition to the whole pick up and drop off locations and ring cameras, there's no evidence that the attorney ever reviewed those records. That would be the first thing any experienced attorney would do. And you need to have an experienced attorney. They don't teach this in law school about, well, this is how you file a complaint, this is how you draft a motion. No, experience teaches you know what those records say before your client goes in to meet with the friend of the court. If they're harmful, then you're going to go on to the next step. If they're beneficial, make copies, provide them to the friend of the court because it's going to help your case. If they're harmful and you aren't benefiting from your counseling or you're aggressive in counseling, go get experts. In this case, there is no record that there were any experts involved on behalf of mom. Get anger management counseling. Get a fitness to parent evaluation from another expert. There's no indication that mom did any of those things. You need to be able to provide new evidence, additional evidence, alternative evidence to offset husband's claims. The mom in this case didn't do that. Now, secondly, there's a different evidentiary standard in the criminal court versus in family court. Criminal court, everybody knows it's beyond a reasonable doubt. In that case, maybe there was reasonable doubt whether or not she intended to be violent or intended to commit domestic violence. But her aggressive behaviors with the police arrest, the ring camera, all add up. And that's what the family law court looked at. So in its 37-page opinion, it barely referenced the not guilty verdict, but it did reference the ring camera, the body cam footage, the fact that mom's conduct was constantly violent, aggressive. She didn't disclose her records, so she looked dishonest. And so the family law court is just looking at the best interest of the children. And it has to go through all those 11, 12 best interest factors. And we have videos on each one of those in detail. So if you're going through a custody fight, or you're going to be going through a custody fight, review them all and know what you have to prove to a court. Bottom line, I hope this was helpful. Subscribe if it was. Until next time.